Asian Americans in an anti-Black world. Let's see, page 94. Okay, going through from page 94, some of the text that stood out to me was each from the Civil Rights Act of 1875, which there are quite a bit, and at the last paragraph of the section, it says that each served the other in stabilizing a property regime and social order built upon the phobic avoidance of Blackness. That says a lot. Oh, maybe I should move this. And then going into the Yick-Wo and Plessy or Jim Crow's alibi, what stood out was the 1890 Louisiana statute, which informally known as the separate car law, that required railway companies to provide equal but separate accommodations for the white and colored races. During Reconstruction, the Louisiana State Convention had written a new constitution which guaranteed all citizens the same civil, let me rewind, and they quote, the same civil, political, and public rights, and explicitly prohibited segregation in public accommodations, including, end quote, any conveyance of a public character. The Democrats who took over the state legislature and governorship after Reconstruction wrote a new state constitution aimed at consolidating Jim Crow. The separate car law of 1890 was a part of this effort. The New Orleans Creole Organization, which I'm not going to butcher because I believe that's French, and I don't speak French. Citizens, which basically is a citizens committee, challenged the segregation statute in court, which composed of persons of mixed descent. Okay, let me fast forward to the part that makes a whole lot more sense, because the rest of this section didn't make a lot of sense to me until I got to this section right here. Racial indeterminacy, I probably just butchered that word, had revolutionary implications because it meant there was no objective basis for a system of racial segregation. Without a foundation in nature, Jim Crow would be revealed as unacceptably arbitrary. In practice, I think it's Torget pointed out, it was left to the railway conductor to determine who was white and who was colored, a call he was neither authorized nor qualified to make. Sorting people by race on a public conveyance, we're going to call him T because I'm not trying to butcher that name again, which is, from my understanding, is an attorney, continued violated the 13th and 14th Amendment. Slavery, he wrote, was a caste, a legal condition of subjection to the dominant class, a bondage quite separable from the incident of ownership. Ownership of Black people, what he called catalysm, ceased after the Civil War, but slavery as a Black-white caste system did not. against those who read the 13th Amendment narrowly as dismantling the formal institution of slavery and nothing more. T proposed an expansive reading of the 13th Amendment as a live instrument for fighting ongoing Black subordination. The purpose of this amendment was not merely to destroy catholism and involuntary servitude, but the estate and condition of subjection and inferiority of personal right and privilege, which was the result and essential concomitant of slavery. The separate car law ran afoul of the amendment. The effect of a law distinguishing between citizens as to race in the enjoyment of a public franchise is to legalize, cast, and restore, in part at least, the inequality of right which was an essential incident of slavery. In addition, T argued the railway conductor had deprived Plessy of his liberty and property without due process of the law, a violation of the 14th Amendment. Plessy had lost not only the value of his ticket, but another form of property as well. Let's continue. The man who rides in a car set apart for the colored race will inevitably be regarded as a colored man, or at least be suspected of being one. And the officer has undoubtedly the power to entail upon him such suspicion. To do so is to deprive him of property, if such reputation is property. Whether it is or not, is for the court to determine from its knowledge of existing conditions. Perhaps it might not be inappropriate to suggest some questions which may aid in deciding this inquiry. How much would it be worth to a young man entering upon the practice of law to be regarded as a white man rather than a colored one? 19/20 of the property of the country is owned by white people. 99/100 of the business opportunities are in the control of white people. Probably most white persons, is given a choice, would prefer death to life in the United States as colored persons. Under these conditions, is it possible to conclude that the reputation of being white is not property? Indeed, is it not the most valuable sort of property, being the master key that unlocks the golden door opportunity? Bruh.